Now let's discuss what is partnership deed. Now, we have learned what is the meaning of partnership. Partnership is nothing but it's a relation between the partners who have agreed to share the profits in the business carried on by all, or any of them acting for all. We know what is partnership, but what do you mean by deed? Deed is a legal word meaning a written intention, a written agreement in short. It's an intention of the partners to put their intention into writing. It is the willingness of the partners to put their thoughts into writing, to put the agreement into writing. So, deed means intention or agreement in writing. Okay, so when the partners come together, they decide on certain things relating to partnership and then they put it into writing. This is called as partnership deed. Now, along with the prescribed form, if the partners have made a deed along with the prescribed form and paying the fees, the partnership deed also needs to be submitted with the registrar. Okay, but many times partners do not feel that registration of the firm is important, so they do not make any partnership deed. So it is always advisable that when you make partnership, you make a partnership deed, because that is the written evidence, and then you get the firm registered. Okay, now I'll explain you what exactly is partnership deed. We have understood that partnership is the agreement between the parties. It is a contract between the partners. So a contract or an agreement, it may be express or it may be implied. It may either be express or it may be implied. Now, if it is express, it may either be oral or it may be in writing. Okay, and when this agreement is in writing, it becomes partnership deed. You're getting my point? So when partners come together, they form an agreement or a contract and then they put it into writing. This gives birth to partnership deed. So an agreement in writing by partners is called as partnership deed. Now, what are the contents of the deed? Let's see. A partnership deed should contain the following clauses: name of the parties or the partners who are forming the firm. This is very basic. Okay. Second, nature of business that the partnership or the firm would be doing. What kind of business they are getting into. Duration of partnership, if any. Okay. Next, name of the firm. You had name of the partners, now you give the name of the firm also. What is the capital that each one is going to bring in? Now this is very preliminary at the first stage when you are making the partnership deed. Now this capital may keep on changing as you keep on doing the business. In due course, your capitals may fluctuate. At times you may bring in fresh capital, or you may withdraw, or the amount of profits get added to your capital. So the figure may change, but when the deed is made, how much amount everybody is bringing in, how much amount everybody is contributing in, this may be mentioned. Share of partners in profits and losses. Now this is the PSR, profit sharing ratio, that we were talking about. All along in this act we have been, there have been a lot of topics where we have discussed about profit sharing ratio, PSR. Now this needs to be mentioned in the partnership deed. Next, which bank is the partnership firm banking with? What is its account name? What is its number? That needs to be mentioned. Who will make the books of accounts? How will the books of accounts be made? Where will the books of accounts be kept? What is the time and duration of inspection? Who can inspect them? All these things relating to books of accounts, they can mention there. What are the powers of partners? There may be a case wherein some partners are given more power, some partners are given less powers. Or there may be a case wherein all partners are given equal powers, and if they are given same powers, what are the different powers they are given? Okay, so this will put it into writing. This will lead to lesser disputes. Now if you want to give somebody more power, if you want to give somebody less power, now you are the person who's deciding that. You together, it's a unanimous decision that you are making. So what happens is, many a times a partner may stand up and say, no, I do not agree to this, and then you do not have any written proof to show to him. But when you put all these things, now this is a very sensitive matter, the power of partners. This is a very sensitive matter, so it is always advised that you put all these things in the partnership deed. Next, retirement and expulsion of partners. If a partner can retire from the firm or no, if a partner can be expelled from a firm. When we were doing expulsion of partners, we said expulsion is invalid. It becomes illegal if the firm, the partnership deed does not allow it. As long as it is there in the deed, then you can expel the partner. But there's no clause of expulsion of a partner in the partnership deed, then you cannot expel the partner, and if you do so, your expulsion is illegal or invalid. So clauses relating to retirement, how can the partner retire, if he can do a competing business or no, if there are any restrictions on his business, clauses like these. Death of a partner. What happens in case of death of a partner? Do the accounts get settled immediately, or the capital of the partner is given to legal heir or no? How will it be treated? Will the legal heir be given interest, or he'll be given profits if his capital is not paid? So various clauses relating to the death of partner. Dissolution of the firm, very important. What will be the rights and liabilities in case of dissolution? How will dissolution happen? Who will carry on the dissolution? What are the various methods in which the firm may be dissolved? Does the partner have the right to dissolve the firm? So all these things can be put under this clause. And finally, settlement of disputes. What are the kind of disputes the partners can foresee, and in those disputes, how will they be resolved? Partners may put on various cases, as in if there is a dispute relating to profit sharing ratio, if there is a dispute relating to admission of partner, if there is a dispute relating to expulsion of a partner, if there is a dispute relating to relating to books of accounts or the business of the firm. So how these disputes will be resolved? If a third party will be appointed, an arbitrator will be appointed, or they'll sit amongst themselves and resolve it, or there's a percentage set. The resolution can be by any method which they mutually agree. But then, penning it down gives them a legal, I wouldn't say legal, a written evidence that the partner had earlier agreed to this resolution. Okay. So now we have a list before us as to what all should be there in the partnership deed. But this list is not given in the act. This list is only illustrative. It gives you examples as to how a partnership deed should look. Now, it is not necessary that only these items should be there in the partnership deed. You may have 100 of other clauses. You may have 10 more clauses. You may not want to add 3 or 4 clauses from this list. So it entirely depends on the partners. This is only illustrative. Okay.